but not really in the sense of very broad, very difficult social issues that seem to dominate the news and that will sort of animate, I imagine, the discussion that we have here today. Those are rare in terms of numbers on the dockets. But in terms of motions to suppress on the Fourth and Fifth Amendment, prisoner, pro se civil rights cases, or habeas corpus cases, First Amendment issues, voting right disputes, a lot of different forms of discrimination claims. Those are very often before the courts for decision. I think the more interesting question is how often is it a difficult issue and what to do with it when it is. And again, for a district court judge, it is less often a difficult question than you might think. And that's because I do believe that all district court judges start with the idea of precedent and look at what is out there and what has decided and guided the path on the particular issue, and will observe the pronouncements of their circuit court or the Supreme Court. But when it is a difficult issue, I would note that there is some significant overlap on and areas of agreement on how to approach the issues. I commend to everyone to take a look at the brief books, Competing Views by Justices Stephen Breyer and Justice Antonin Scalia, Active Liberty for Breyer, A Matter of Interpretation for Scalia, because they agree on four touchstones that pertain to the analysis, being language, the text that's used, history, what was going on, and what the problem was that needed to be resolved, tradition in the regard that's at issue, and precedent. And Justice Scalia would leave it there, but Justice Breyer would add purpose and consequences. And I would imagine that in the response, Professor Levinson will address those very well and make the argument in favor of those. So with that, I do think that I will leave it now to the scholars on this panel to eliminate the topic, and I will turn it over first to Professor Worman.
Great. Well, thank you for having me and for the introduction and those preliminary remarks, Judge Eskridge. I did this talk at the University of Texas 4 years ago or 3 years ago, and if I were there in person, I did have flights to come and do this. I'm sorry to have had to cancel them, but I would do this whole song and dance for about 25 minutes. But because I only have about, because it's Zoom rather, I should say, I'm going to keep it to about 15 minutes. So it's not quite the full version, but you'll have to, I guess, purchase the book for the full story, so to speak. Unfortunately, it's cheap. I like to say it has three virtues. It's short, it's cheap, and it has a really amazing cover. Now, I also happen to think it has the fourth virtue of being correct, which is more a matter of dispute and something I hope to convince you of in the next 15 minutes. Okay, let's get started. I submit that the best way to defend originalism, at least in 15 minutes, is to ask, how do we ordinarily interpret law and other legal instruments in our legal system, like contracts or statutes or treaties? So ordinarily, we separate the questions of what a contract or statute says from whether that contract is enforceable or that statute is binding, right? So in retrospect, we may have entered into a bad business deal or a bad contract, or maybe Congress has enacted a bad law. But very much an integral part of our legal system is that we are nevertheless bound even by the bad contracts we've properly entered into, just as we're bound by the bad laws that Congress enacts. Why? Why is that? Why are we, for example, bound even by Congress's bad laws? Well, because in our legal system, we recognize that so long as the laws are enacted pursuant to a particular process, a democratic process, right? The assent of 2 representative houses of Congress, a nationally representative president, that process is sufficient to confer legitimacy on the laws, such that they are binding as a whole, even those of them we do not like. Well, can't a similar framework apply to the Constitution? A similar framework. After all, the Constitution is also a law. It's a law that we, the people, enacted to govern and bind our legal officials. So the originalist position then is to first ask, what does this Constitution even say? What does it do? What kind of legal regime does it create? Now, it may turn out that once we figure all that out, we don't like everything it says. Maybe we don't like some of its provisions. Maybe we think we can do better. But is there an argument that we are nevertheless bound by the Constitution as a whole, despite any imperfections it may have or any particular clauses we do not like, just like we're bound by the laws of Congress as a whole, even those of them we don't like? So for the originalists, in sum, there are two inquiries, I think. The first is, how do we figure out what this Constitution even says or what it even does? And once we figured that out, we still have to ask the second, harder question. Once we know what it says or does, is this Constitution even binding, such that we should care what it says or does, such that we should follow what it says or does, just like we follow the laws of Congress, because we consider them to be binding? This is the much harder question, and what makes a Constitution binding is going to be much more complicated, right, than what makes, say, a law of Congress binding. Okay, so these are sort of the two inquiries, and I'd like to go through both. So the originalist answer to the first question, the first inquiry, is easy, I think, easy-ish. I think we interpret all legal instruments in our legal system the same way we would interpret a communication intended as a public instruction. So interpreting the Constitution is in principle no different than interpreting a recipe for apple pie or fried chicken. This is to borrow Gary Lawson's analogy. Suppose you found a recipe for fried chicken in your great grandmother's attic. It was dated from 1789 and was written in Philadelphia. Well, how would you interpret it? Right? Well, you would use a public meaning, not a secret meaning or esoteric meaning or poetic meaning. Right? This recipe, this instruction, is not a Socratic dialogue. It's not a novel. It's not a poem. It's an instruction. So you interpret it with a public meaning, and I think you interpret it with its original meaning, with the meaning the creator of the recipe intended to convey at the time it was written. Now, that is not to deny the existence of interpretive challenges as a result of indeterminacy or underdeterminacy, like vagueness or ambiguity or breadth. And so the recipe might say, add pepper to taste. Right? Well, what do we do with that? So it certainly will be the case that faithful chefs trying to implement this recipe will arrive at a range of plausible actual outcomes in the world, a range of actual fried chickens. Okay, a range, yes, but a circumscribed range. So a chef couldn't just add rosemary to taste instead of pepper to taste because the chef concludes that modern day fried chicken eaters prefer rosemary. I mean, a chef could do that, but make no mistake about it. That wouldn't be interpreting the recipe. It would be amending the recipe. Well, it doesn't take a rocket scientist to figure out where this is going. The Constitution is also a public instruction. It's an instruction from we the people to our legal officials. So we interpret the Constitution with a public meaning, not a secret or esoteric or poetic meaning. Again, it's a constitution we are expounding, not a poem, not a novel, not a Socratic dialogue. So I think we interpret it with a public meaning. And I think that means we also interpret it with its original meaning, the meaning we the people intended to convey at the time it was written when we sought to bind our legal officials. But again, there will always be these interpretive difficulties as a result of those same underdeterminacies or indeterminacies. So I do think it will be the case that faithful interpreters of the Constitution will arrive at a range of plausible originalist answers to many constitutional questions. Okay, but again, a range is still a range. So want to emphasize that. Okay, I think that's the easy part. So are we all originalists now? Well, Justice Elena Kagan says that we are, but the argument is not enough. I don't think it goes far enough for those who claim that we aren't even bound by the framers' Constitution at all, because the Constitution is different from other laws. It's old, it's outdated, and it happens to be very hard to change. If all of these premises are true, then non-originalism isn't crazy. Maybe we want judges to update the meaning and content of the Constitution over time as a sort of second best amendment process. Note that I don't think this makes non-originalism a theory of interpretation. I think this means non-originalism is a theory of constitutional change. Here's what I mean. Even in a non-originalist system, something will get its original public meaning, namely the judicial opinions posted on the internet every Monday and Thursday morning. Okay? When a judge issues this opinion, the citizens and officers tasked with abiding by it or enforcing it still have to figure out what the opinion requires of them, what it prohibits them to do, what it compels them to do. They'll interpret these opinions with their public meanings. That doesn't change. What changes is what source of law we look to supply the content of our constitutional rules. Is it the paper under the glass at the National Archives? Or is it those opinions on PDF files posted on the internet on Mondays and Thursdays? Okay, so I think that takes us to this second inquiry, which is the valid source of law, or I should say, is that paper under the glass of the National Archives, does that paper legitimately bind us such that it supplies the content of our legal obligations, such that we follow its original public meaning as opposed to the original public meaning of, say, the Supreme Court opinions? Obviously, I'm pivoting now to the second inquiry, right? What is the argument for why the Constitution is binding like the laws of Congress are binding, such that we should care about its meaning, that we should follow its original meaning? Well, I claim, and I obviously at this point do so in much more detail in my book, that the Constitution is binding if it is an improvement of the kind that James Madison described in a letter to Thomas Jefferson. If it's an improvement that forms this, what Madison called a debt against the living. What must the Constitution do to be this improvement and to create this debt against posterity, against future generations? Well, I argue that for a Constitution, at least for a society like ours, to be legitimate and binding, must accomplish one central task. The Constitution must successfully balance the two principal and competing objectives of a free society: self-government and liberty. On the one hand, a constitution for a free society must, on the one hand, as I said, just create this regime of self-government whereby we, the people, can govern ourselves and choose who we want to be politically, socially, culturally, economically, and yes, even morally. And on the other hand, this exact same piece of paper, this exact same constitution, must preserve a large measure of natural liberty. Otherwise, why would we have gotten out of this state of nature into this thing called civil society if we were made worse off by doing so? But as we know, these two objectives, self-government and liberty, are in tension. As we all know, it is often popular majorities that infringe on the rights of minorities. So framing a constitution that successfully balances these competing objectives is not easy. And my claim is that the framers were remarkably successful for their time at creating a constitution that balanced these competing objectives through ingenious mechanisms, right, of which those here hardly need reminding: separation of powers, checks and balances, the enumeration of power, the Bill of Rights, and the representative mechanism itself, by the way, was a novelty at the time. But more than that, and more importantly than that, my claim is that the framers wrote the Constitution in such a way that it would continue to strike a successful balance between self-government and liberty long into the future, right, on both sides of the equation. So on the liberty side, this makes sense, right? The rights protecting provisions of the Constitution are written in sufficiently broad terms to be applicable to new and changing circumstances. That's why the First Amendment applies to speech made on the internet. That's why the Fourth Amendment applies to GPS devices that police officers put on cars, right? Many things the framers could not have conceived. Well, on the self-government side of the equation, consider what the Constitution insulates from democratic politics. Very little. I mean, it insulates those rights most essential to free societies, like free speech, press, religion, assembly, and petition, self-preservation rights, if you take the Second Amendment seriously, I guess, and then due process rights. Lots and lots and lots of due process rights. Other than that, the Constitution leaves most other things to the democratic process, precisely because the founders expected we would evolve and progress over time. Think about it. If they didn't think that, they would have baked more into the Constitution to prevent future democratic change. So one might say that the Constitution we have is very much a dead Constitution, but the democracy that it creates is a living democracy. Okay, that was kind of corny, but I don't know, it sounds good. Okay. I'll say one last thing on this, by the way. For the most fundamental of regime changes, they gave us the amendment process. And for as hard as that process to use is, this is how we have in fact used it for those most fundamental of regime changes. So therefore, in semi-conclusion, I'm almost done. So long as we, the people today, not as a matter of blind veneration to the past, but today, here and now, as a matter of present day social facts, if we continue to believe, agree, and accept that the Constitution of our founders, as it has been properly amended, okay, by the Reconstruction Amendments in particular, which is my new book. So maybe when things are better, I can come talk about that. But if we accept that the Constitution, as it has been properly amended, continues today to strike the successful balance between self-government and liberty, then that Constitution, I submit, is an improvement of the kind that makes it legitimate and therefore binding, whatever its imperfections. Because this is an important point, I'd like to restate it one more way. Something must make a Constitution binding. Something must make a Constitution binding. It can't be that no Constitution is ever binding. That just isn't true as a matter of social facts anywhere. Something must make a Constitution binding. On the other hand, it can't possibly be that a Constitution is binding only if it says exactly what you personally would want it to say in each of its particulars. 330 million Americans might have a different opinion about that. There must be some middle ground, some threshold that makes a Constitution legitimate and binding, even in the face of inevitable disagreement over its particulars. I claim that that middle ground, that is this threshold success in balancing self-government and liberty, even if it's not the exact balance you would strike. But true enough, it has to, at a minimum, strike that balance, that minimum threshold. And we have to believe that it does so. Okay, well, if I'm right, that the Constitution is an improvement of this kind that forms this debt against the living, then I think the Constitution is binding law. And if the Constitution is binding law, then I submit we interpret it the way we typically interpret other binding laws, with an original public meaning. Okay, I should probably stop there, but yes, I do want to say one other thing. Though I really probably should stop. That's famous last words. I do think it's important to talk about slavery. The founders also believed, I think correctly, that for the Constitution to be set in motion, for it to be worth more than the parchment on which it was written, it had to be initially ratified by an act of popular sovereignty, by this act of ratification. And I think it is this ground that the founders are most often and correctly criticized. They are correctly criticized, or at least they're criticized, right, for being all white, all male. Many of them were landowners, and many, about half, I think just under, but right about half, were slave owners. And that this precludes us from being bound by their achievement in the Constitution, even as that has been amended and corrected. Now, there's no point in sugarcoating the founders, right? They were white, they were landowners, they were males, and many of them were slave owners. But we don't celebrate them for any of those things because they did not invent any of those things. The founders didn't invent slavery. Slavery had been universal until the founders' time. They were born into that condition. The founders didn't invent the exclusion of women or the poor from the political process. Those two have been universal. Those were conditions into which they were placed. On the contrary, we celebrate the founders for overcoming these historical limitations in important ways. We celebrate them for writing for the first time in a foundational national document that all men are created equal, as a result of which writing, people forget, half the states abolished slavery or set a timetable for abolition between 1776 and 1789. This was the greatest emancipation of its kind in world history up until that point, in the words of the Princeton historian Sean Mullens. So we again celebrate them for giving us the first free government of the modern world, a government that has no property requirements for holding federal offices, that prohibits titles of nobility and hereditary privileges. These were the innovations. And of course, the body of people who would deliberate and reflect on the Constitution and the ratification process was broader than anywhere else in the world and any other time in history. So have we progressed since the founders' time? Yes, of course we have, and a good thing we have. But we've done so largely because we stand on the shoulders of their achievement. Okay, I'll really stop there now. Thank you for your attention.
Thank you, Professor Werman. Professor Levinson, your response, please.
Thank you. I really do wish we had much more time. So let me just touch on a very few things in roughly 10 minutes. I want to actually begin with Judge Eskridge's initial comment, because I think it's extremely important. In fact, I wrote this in an article, it must now be about 30 years ago, published in the Federal Society Journal, because I gave it at a Federal Society conference, that the whole debate about originalism is a strange debate, because none of the judges that the Constitution, I think, incorrectly labels inferior judges is an originalist. Judges, as Judge Eskridge pointed out, for better and for worse, feel bound by precedents of the United States Supreme Court. And it is often the case, wherever you are on the political spectrum or interpretive spectrum, it is often the case that you're not going to like what the Supreme Court has given you. But Judge Eskridge, none of the other roughly 900 federal judges at the district and circuit level is empowered to say, you know, the Supreme Court got it wrong on the basis of whatever your favorite constitutional theory is, all the others. It doesn't matter. So the debate about originalism really ends up as a debate about what you want Supreme Court justices to do. That's one thing I think ought to be understood. And we could spend a lot of time on that. We don't have a lot of time. So I want to pick up on a couple of the things that Professor Werman brought up. He mentions the issue of obligation. Well, I think right before we began, I mentioned that one of the things, as a devoted non-originalist, I enjoy seeing is originalists fighting with one another. Most of the time, they'll fight with one another about what the one true public meaning of the Constitution is. But they also one another about issue obligations. And Randy Barnett, in his very, very important writings, and I'll say that Randy's a good friend, although we disagree very fundamentally on lots of things. Randy has really argued that the only reason to feel obligated to obey the Constitution is if, in fact, you believe it accords sufficiently a justifiable political theory. But Randy rejects the idea that the foundation of obligation is some mystical theory of we the people, not only because of the obvious point that Professor Werman brings up, that the people in 1787, or if truth be known, in 1868, were a small fraction of the number of people who might wish to have participated in the drafting of the Constitution. And so Randy says you have to come up with something better than a mythical theory of a social contract, and then he supplies that theory with a mixture of libertarianism and natural law. And again, if we had much more time, we could talk about merits of each of those theories, which have their attractions as well as their problems. But it is important, I think, to recognize that any theory founded in contract or evocation of a we the people necessarily requires that you identify the people and that you really come to terms, I think, more than Professor Werman is willing to come to terms with, that the people in Philadelphia in 1787 were either slave owners or those who were willing to accommodate slave owners in order to get a constitution. Now, that might be defensible. There are times when you have to make pacts with the devil. The example I offer in my writings is the alliance between the United States and Stalinist Soviet Union in World War II. I think that was a justified alliance. And it may be, if you think that getting a constitution was more important than anything else. If you read The Federalist, the opening essays of The Federalist are all about the need to unify behind a single constitution and basically to do anything in order to get that. The two essential compromises in the Constitution of the United States Senate, which I despise. I think it is unjustifiable that Vermont and Texas or California and Wyoming have the same two votes in the United States Senate. James Madison happened to agree. He referred to that feature of the Senate in Federalist 62 as an evil, and he was correct. He then went on to say, well, it's a lesser evil because what's the greater evil? No constitution at all. The same thing was true for some Northerners, not for Madison, who was a slave owner and supported slavery, but for some of the Northern opponents of slavery, he agreed with the same logic. Slavery was an evil, but it was a lesser evil than no constitution at all. So I mentioned also before we went on air, so to speak, that I'm teaching a reading course at Harvard this term on Frederick Douglass and Abraham Lincoln. And I think everybody should read, actually, the two things that began the course quite literally yesterday. That is Abraham Lincoln's Lyceum speech in 1838, which is a speech all about the sacredness of the Constitution and the duty to obey every part of the Constitution, even though he admitted some parts that were unattractive. Lincoln was anti-slavery, but better to say to enforce the fugitive slave law than run the risk of anarchy and the consequences of that. Then one can follow that with one of the great speeches in all of American history, which is Frederick Douglass's "What to the Slave is the 4th of July," delivered in 1852, in which he uses brilliantly the words "you" and "yours," in which he says, well, I can understand why you will celebrate the 4th of July, because you, that is his basically white audience, were the winners in 1776 and in 1787. But there is no good reason for any enslaved person or a fugitive slave like Douglass to celebrate either the 4th of July or the Constitution. And I think we really have to wrestle with that. Now, Professor Werman accurately said did improve Constitution the Reconstruction Amendments, and I look forward to reading his book. But it is essential to realize that we improved the Constitution because 750,000 people died in a war, either war between the states, if that's the way you wish to phrase it, or a civil war. It kind of really doesn't matter, because the important thing is that 750,000 people died. And if you look at the countries that abolished slavery in the 18th and 19th century, only the United States needed the slaughter of 750,000 people to do it. Serfdom was abolished peacefully. It was abolished in the British Empire in 1833 peacefully. It was abolished in Brazil later than the United States, incidentally, in 1888 peacefully. But then you look at the fact that it required a war. It's important to realize that Abraham Lincoln, in his first inaugural, accepted the so-called federal principle or federal compromise, which required acknowledging the legitimacy of slavery in the states where it existed forever. He supported an amendment to the Constitution that would have recognized that principle. You can say, well, at that point, it was only 15 of the roughly 36 states. That's the good news. Most states were so-called free states, but the bad news is that 15 were not, and Lincoln was quite willing to accept the legitimacy of slavery in those states. And Frederick Douglass, not surprisingly, excoriated Lincoln for that aspect of his inaugural address. So I admire Professor Werman for acknowledging the problem of slavery, but I think that his argument is much too facile in presenting a reassuring argument that the original Constitution, the DNA of the original Constitution, was only self-government and liberty, rather than to wrestle with the fact that only some selves were recognized as being part of the self-government project. We're much better now than we were, but the initial public meaning was not inclusive in the way that it is today. And furthermore, liberty included the liberty of slave owners. And I really do think that originalism fails to come to terms, to full terms, with the relevance of slavery to constitutional interpretation. I want to address one other point. I think that Professor Werman makes a fundamental error in running together private law and public law. I think he's probably right that if I enter into a contract with Judge Eskridge or with Professor Werman, it is reasonable to look to the intent of the parties. And if you accept the parole evidence rule, then we're going to look to the original public meaning of what we mean by chicken, to cite very famous classic first-year contracts case as to whether the chickens are stewing chickens or roast chickens or whatever. I don't have any problem with that theory of interpreting contracts or wills. I do think that people in the 18th century were fully capable of distinguishing between private law and public law. And so that when Marshall says, in the opinion that I obsess on in my constitutional law course, I do not teach Marbury versus Madison because I think it's a waste of time to spend the time required to teach Marbury well. Instead, I spend inordinate amount of time on McCulloch. And Professor Werman cites one of the key sentences. Felix Frankfurter thought it was the most important single sentence of American history that we must remember is the Constitution we are expounding. I always found that mysterious, because what else would it be, until I connected that with a sentence about 7 paragraphs later, where he said, a Constitution is designed to endure. And if it is to endure, it must be adapted to the various crises of human affairs. So then we can argue about who does the adaptation. Is it Congress? Yes. Is it presidents? Yes. As an empirical matter, we can like this or not. And on occasion, it is judges. But it is a fundamental mistake to overemphasize the importance of judges in the process of adaptation. It's simply not true that the Supreme Court is the continuing constitutional convention. The continuing constitutional convention, if you want to use that metaphor, is Congress and the president. You can add the administrative agencies if you wish. You can also add American states if you wish. And the most important thing that federal judges do, as a matter of fact, is what was done in McCulloch versus Maryland, which was to legitimize what James Madison in 1791 denounced as the overreaching of congressional power by chartering the first bank of the United States. Now, again, originalists can bicker with one another as to whether Hamilton or Madison, two of the three co-authors of the Federalist Papers, is the more reliable guide to the original public meaning and that sort of stuff. But what is truly significant is, I think, the theme of adaptation. Madison himself signed the second bank bill in 1816, not because he concluded that he was wrong in 1791. He never said that. I think what he concluded as a result of his having become president and gotten us in the War of 1812, which we could talk about, in another venue, is that it's a really good idea to have a central bank. And so he signed the bill establishing the second bank of the United States, and John Marshall said it was perfectly fine. So I think that any originalist has to wrestle with the issue that Judge Eskridge identified at the very beginning. What obligations do we owe precedent, whether it's congressional, presidential, or judicial statements? And to what degree do we honor those precedents that we believe are in fact necessary adaptations to the various crises of human affairs, whether it is slavery, we're getting rid of slavery, whether it's depressions, whether it is a pandemic that so far has killed 650,000 Americans. Depending on where you are in the political spectrum, you may offer different examples of the crises that face us. But we don't live in a world, we have never lived in a world without crises that we have to adapt to. And Marshall was right. The Constitution is a public document. It's not a will. We, the people, have to govern ourselves rather than to fall back on the comforting myth that a particular set of demigods drafted a statement in 1787 that we are stuck with, even if we think that adhering to it will take us over a cliff. Let me say one final point and then I'll stop. In a book that I wrote, I distinguished between what I call the Constitution of Settlement and the Constitution of Conversation. The Constitution of Settlement is basically the hardcore textual Constitution. So I said a few moments that I really hate the United States Senate, which is true. But I also believe that one cannot argue that it's unconstitutional for Texas and Vermont to have the same number of senators, because I will whip out my copy of the Constitution, point to it, and say, what part of 2 do you not understand? Similarly, I think it is unwise, even dangerous, as we learned this past January, to wait until January 20th to inaugurate a repudiated president. But that's an issue about wisdom. The lawyer's answer to the question is to point to the 20th Amendment and say, what part of January 20th do you not understand? And for better or worse, that's a knockdown legal argument. But then there's the rest of the Constitution that I call the Constitution of conversation, that is much more open-ended, much more indeterminate. And as Judge Eskridge correctly predicted, I do stand much more with Justice Breyer, and I would argue with John Marshall in McCulloch versus Maryland, that we have to ask, what is the Constitution doing for us today to allow us to respond adequately to the crises we face, even recognizing that there might be certain aspects of the Constitution, like the allocation of voting power in the Senate, that we really are stuck with.
Thank you. Professor Werman, do you want to respond?
Do I ever?
To aspect of, I know, and we will run out of time on questions, but I feel compelled to toss it back to you to respond. And with whatever we have left, we do have questions in the queue that I'll get to, but go ahead.
Yeah, we can, of course, stay 5 minutes over, though I know it's everyone's dinner time over there in Texas, so I won't. There are 4 things I want to say. In 2 to 3 minutes max each. So that'll save a few minutes for questions. First, this point about this, originalists, this joke about the originalists debating over the one true meaning of the Constitution. I really don't think we do that anymore. I just want to be clear. I do think some things are clear one true meanings, and others, I think there's a range of plausible meanings, but a range is still a range, as I said, so we debate over the privileges or immunities clause. Randy Barnett, Kurt Lash, and I have 3 different views of the clause, but still, I think, that still excludes certain possibilities. For example, I think political rights aren't included within the privileges or immunities clause, which I think means one person, one vote's inconsistent with the original meaning. I think that disposes of political gerrymandering cases, things like that. It's still sufficient to give us answers and to preclude, certain non-originalist answers. But Professor Levinson's point was more about, we also disagree about the grounds of obligation. And that's true. But what I think no one can disagree with, even Randy Barnett, I think, when pushed to this, is that ultimately, whether the Constitution is binding is a matter of present day social facts. Okay, I'm a positivist as far as that goes. Whether the Constitution is binding depends on whether we treat it as binding or not. And the question is, why should we or should we not treat it as binding? And Randy, I agree, says, well, we have to come up with something better than this mythical social compact. And I agree, which is why I didn't mention slavery and the founders and their flaws until the end. My argument isn't about the founders. My argument is, if we, the people today, continue to believe as a matter of these present day social facts that the Constitution balances self-government and liberty, then that Constitution is binding. I'm not saying we can't have another constitutional system that meets these requirements, like a non-originalist constitutional system could still balance self-government and liberty. I think it does so much worse than the Constitution we have. And I think there are risks associated with letting judges update the Constitution in that manner. But that's a normative debate that we can have. And who's right will depend on who we convince, how many people are convinced, and whether as a matter of present day social facts, we believe that the paper under the glass of the National Archives is what supplies the content of our legal obligations. I simply defended the founders because it's hard for people to get over the fact of slavery, okay, and that they were all white male landowners. But it wasn't actually crucial to my argument. We could say, yeah, look, today, if we had the Constitution of 1788, okay, 1789, if we had that Constitution today, no Bill of Rights, even, no Reconstruction amendments, yeah, I would be like, forget it, throw the whole thing out. Let's have a revolution. Let's have a new constitutional convention. But the whole thing is hypothetical because, and it's academic, it's moot, because as society progressed, as we advanced, we brought the Constitution along with us. So the only question we can answer is whether the Constitution we have today continues to strike this balance. And I think it does. That took too long, so I won't make my defense of Lincoln, except to say, no, I won't talk about Lincoln. Okay, though I think it is defensible, the view that he took. The last two things I want to say are about McCulloch and Chief Justice Marshall. I really don't interpret his opinion in McCulloch as saying that the Constitution, it's often taken, that it's a Constitution we're expounding, has to be adapted to the various crises of human affairs. It's often taken for this proposition that he was sort of this living constitutionalist. It is entirely in the context of what does the and proper clause mean. That's what it is. Let's see if we can, I don't have host privileges, but okay. It's entirely, the question is, what does the necessary and proper clause mean? And the answer is it's a grant of implied powers. What are implied powers? They are powers that are lesser than these great and important powers that had to be expressly enumerated, right? So only certain things can be left to implication. Okay, if I authorize you to come into my office and take a book off the shelf, there is a lesser implied power to go around and find the book and move my books around. Maybe you could step on my chair to look for it. All of those things are implied. I don't have to expressly authorize you to do that. What if the door to my office is locked? Does that mean because I authorized you to go get the book that you can break down the door? No, because that power would be too great, important, a substantive prerogative that you couldn't do without explicit textual authorization. This is what Marshall is saying, okay, in McCulloch v. Maryland, right? He is saying, all right, that these great powers, he says, the power to tax, to war, if they hadn't been enumerated, you couldn't leave those to implication. However, when it comes to the lesser powers, surely we couldn't expect Congress to have listed them all out, because then the Constitution would take on the prolixity of a legal code. So when it comes to those lesser powers, right, those implied means in furtherance of these greater powers, yeah, of course the Constitution is going to leave it up to Congress to come up with these means, these like incorporating an institution, right? And Congress can come up with different means over time. And in that sense, the Constitution is adapted to the crises of human affairs. But today, the non-originalist Constitution allows Congress to do a lot of things that I think would have been understood as great substantive prerogatives that would have had to be textually enumerated, like the power over internal commerce, right? To take just sort of a one example. By the way, Gibbons v. Ogden, 1824, Marshall said the following about the framers: as men whose intentions require no concealment, generally employ the words which most directly and aptly express the ideas they intend to convey, the enlightened patriots who framed our Constitution and the people who adopted it must be understood to have employed words in their natural sense and to have intended what they have said. So I think public law, private law, I think as at least an initial cut, 95% of cases, it's going to be the same. Okay, last point, truly quickly, Constitution of conversation. That's a lower order question. That's a merits question. Is the Constitution truly as open-ended and vague as Professor Levinson suggests that it is? And in my new book on the 14th Amendment, I suggest that due process of law, equal protection of the laws, these are not these open-ended provisions that everyone thinks they are. They're actually quite narrow. They have these technical legal meanings. Same thing with necessary and proper, by the way. As I just said, same thing with the 9th Amendment. That's a lower order merits question. Won't get into all that here, but get my new book or have me in the spring to debate it with somebody. So that's all I'll say. And now I guess we have a few minutes for questions.
We do have a few minutes for questions. We've had several come in, and I have two that I've sort of formed from them that I think gather a lot of the concerns that I'm seeing in them. So we've talked. Professor Levinson was talking about the adaptability of the Constitution, and the idea of also deferring to later courts, deferring to what Congress has done and presidents have done and precedent, et cetera. So my question on it is, To what extent has the idea of the living Constitution stemmed from the very difficulty of amending the Constitution as per Article 5? And for Professor Werman, what does the provision of Article 5 itself say, strengthening the case for originalism? Professor Levinson, when you respond, I would be interested. I know that you have suggestions for thoughts on amending provisions of the Constitution and what you think about amending Article 5 and how it is to be amended, and what that might mean to lessening distress that we have these days about interpretation issues, as opposed to changing the actual textual law. Professor Werman?
Yeah, so briefly, I think Article 5 cuts both ways, doesn't it? Because someone could, the originalists say, well, it says right there, this is how it's supposed to be amended. So you can't just have judges making it up. But that's kind of a weak argument, I think, because the response would just be, well, it's so hard to amend that itself makes the Constitution illegitimate, such that it's okay if we subtly overthrow that regime and judges impose this new constitutional regime whereby judges get to update and tweak it over time. And so it can go both ways. In my view, Article 5, the argument, if to the extent it supports originalism, is that it's hard to amend the Constitution, but that's a good thing because the Constitution got most things right in terms of this minimal threshold. It doesn't answer many questions, but it enables self-government. It protects the most essential liberties. That's all it really needs to do and should do. It should leave everything else sort of to the democratic process. The most fundamental of regime changes should still be submitted through Article 5, and it has allowed that. And that makes it legitimate. If Article 5 basically said you can't amend this Constitution at all, or required 75% of Congress and 90% of the states, I think that would be pretty bad and might in and of itself, require rejection of the Constitution. I will say I would prefer it to be a bit easier to amend, but not that much easier. So it's sufficiently within that range, that threshold that I was talking about, and that's the argument I would make about it.
Professor Levinson, what are your thoughts?
Yes, first of all, it is certainly true that we live today in a better constitution than was the case in 1788, but the United States Senate and Article 5 are the leading examples of the 1788 Constitution that continued to afflict us, and I use that verb advisedly. And the US Senate is very interesting with regard to Article 5, because not only is it unusually difficult, in fact, the United States Constitution is the most difficult to amend constitution in the entire world, but with regard to the Senate, it basically is impossible to amend it through Article 5 because you need unanimous consent of all the states. And it is, shall we say, difficult to imagine the two Dakotas giving up their entirely unjustifiable 4 votes in the US Senate, or for Vermont to give up its equal vote with Texas. And I pick on Vermont and Texas in part because it's no secret that I much prefer Vermont's 2 senators to Texas's 2 senators. But that's obviously a thoroughly political statement. And I think it is unjustifiable, whatever my political preferences, that the 2 senators from Vermont have the same power in the United States Senate. So just as I think that the Senate, I agree with Madison, the Senate is an evil that we have not gotten away with. So I think that Article 5 in fundamental ways is an evil. The most important article of the original Constitution was Article 7. And the reason that was the most important article is that the framers simply disregarded Article 13 of the Articles of Confederation requires consent of the state legislators of the Union created by the Articles of Confederation. The framers realized that that was a lunatic requirement. From my perspective, the most important of the 85 Federalist Papers is number 40, in which Madison explains why the framers simply disregarded the articles. And so Article 7 says we get this new constitution if conventions of 9 states, conventions, not legislatures, nine, not 13. And one of the things that I always impress on my students is the importance of the fact that when George Washington was inaugurated, there were only 11 states in the Union, because my home state of North Carolina and Rhode Island had not yet ratified. That's really important. I actually share the admiration of the framers in some very real senses. What I admire about them is their audacity in describing the system of government under the Articles of Confederation as imbecilic, and their willingness at the convention to do what they thought was necessary to adapt the government of the United States to the crisis facing the United States in 1787. So the people I criticize, frankly, are not the framers. To err is human. The people I criticize are us today, who have none of the audacity of the framers in terms of a willingness to ask what in the 1787 Constitution is worth being devoted to, or the 1868 Constitution, and what parts of the Constitution very much need change. That, I think, ought to be the central question before us. Originalism is interesting for professors and for Supreme Court judges. I would come back to my original comment and Judge Eskridge's original comments that the debates about originalism and whether you're Ashian or Mannian or a Barnett meaning of the Privilege and Immunities Clause is not really an issue. For better, have a privilege or immunities case, which would be unlikely given that the Privilege and Immunities Clause was gutted by the Supreme Court in the slaughterhouse cases. I suspect he would actually feel required to read the slaughterhouse cases and to read some later cases in which Justice Scalia himself basically said, well, only academics and Justice Thomas care about the original meaning of the Privilege and Immunities Clause. We've really gone beyond that kind of debate.
We are at the top of the hour. I'm willing to go a few more minutes and ask another question. I think both of our professors are. If anybody wants or needs to drop off, feel free, but I'm going to plow ahead with one more with permission from the Federalist Society itself. All right, Professor Werman, you had referenced Justice Kagan as making a comment, we're all originalists now. I remember that as her saying we're all textualists now. And we had a question and some other questions about the differences between textualism and originalism. So if you could address that. And Professor Levinson, is that some sort of concession by Justice Kagan? And if so, what meaning or limitation is it? What do you believe she meant by that? Professor Werman, go ahead.
Yeah, so the first thing I'll say is she actually said both.
Okay.
They were all textualists now, and people remember that. But she also, I believe in writing, said they were all originalists. And great, no harm, no foul, because I think they're the same thing. Now, maybe I'm in an insane asylum, but I seem to still be a minority view on this, but they seem obvious to me that they're the same thing. What is, I mean, look, one possibility, okay, is textualism is originalism just as applied to statutes. So statutory interpretation, you interpret the text, constitutional interpretation, we call it originalism, but it's the same thing. It'd be the same method, different documents, okay? A different possibility is that textualism narrowly focuses on text and originalism looks broader than text to things like the founder's intentions or expectations, the background, principles. Well, I submit that's how we actually interpret text. That's how we figure out what a text means. I mean, if a Martian came here, looked at the Constitution, I don't know, maybe they would use a dictionary. That's extra textual. That's not in the Constitution. Maybe they'd say, oh, shoot, look, Blackstone, Article 1, Section 8 lists all of these powers that were listed as prerogative powers of the king in Blackstone. Maybe that actually helps us explain what they were doing, what they meant by these things. Maybe to understand what legislative power is, we need to go to John Locke. This is just how we interpret text. We interpret it in context, the purposes for which the text was deployed, the intent of the specific framers, how they expected it would apply is all evidence of the meaning of the text. So I think textualism, originalism, it's all the same thing. If what textualism is, this idea that whatever contemporary textual readers, right, can plausibly assign to the text, right, contemporary textual meaning. So, for example, the right to have assistance of counsel sounds like it's we have the right to have the government pay for your lawyer. It's plausible under contemporary understandings, right? If that's textualism, then that is different. Okay, but I think that's a very narrow type of textualism. That's contemporary textualism or contemporary meaning textualism. And I think that is just a radically silly proposition because contemporary textualism stands for the proposition, I think, that linguistic drift, accidental shifts in language, determine the content of our law. There's a domestic violence clause in the Constitution. Under contemporary textualism, why doesn't that empower the government to regulate spousal abuse and punish spousal abuse, the federal government? Obviously, it meant insurrection, it meant rebellion. So I don't know of any theory of political philosophy that would allow linguistic drift to determine the content of our law. Another possibility is we just, the right to assistance of counsel is the same. We conceive of a right as an entitlement. Now, that's linguistic drift. That's changed use of words. That's accidental. And of course, it's kind of silly when you think about it, because if the right to assistance of counsel means the government has to pay for a lawyer, why don't they pay for my gun? Why don't they pay for the New York Times printing presses? Well, because it answers itself, because a right within the meaning of the Constitution is the ability to enjoy and exercise some power, right, or some immunity free of government interference if you have the ability, desire, and wherewithal to do it, to exercise it. That's what a right is. And anything else is just linguistic drift, change in meaning. And again, why would that determine the content of our legal obligations? So bringing it back, properly understood, I think they're the same thing. To the extent they're different, I think textualism is kind of crazy in the latter.
Professor Levinson?
Yeah, we don't have enough time really to debate what I would argue are the differences between textualism and historical analysis. When Justice Kagan said that about textualism, I think that she was referring primarily to statutes. And I really wish we had more time to make Judge Eskridge a full participant in this discussion, because I think it is probably fair to say, even though I know really nothing about the specifics of your docket, that you are likely to spend much more time interpreting complex federal statutes than the majestic generalities of the US Constitution. And that it may even be the case that you will have, relatively speaking, cases of first impression on statutory interpretation as against the US Constitution, where quite frankly, you are extraordinarily unlikely to get a case of first impression, which is why I would continue to say that the originalism debate does not have much practical meaning for your daily work as a district judge. So I think what Kagan was saying, and this is important, this places her at least to the side of Breyer, whether or not she is, opposed to Breyer. I don't think she was. They were colleagues, and I think that In fact, in behavior, she was quite Breyerian. But I do think that Justice Breyer, who's from a different generation, obviously, comes out of the Hart and Sachs approach to interpreting law of the 50s and early 60s, where linguistic drift was what law was about. And the explanation for the drift was not judicial willfulness, judges making decisions on whim, but rather trying in good faith to figure out the purposes of ever longer statutes. I mean, if you look at the original US reports, not only the US reports, but US code, you can get through 60 years with one shelf. Whereas today, it's difficult to get through one session of Congress in one shelf, or when you add the administrative agencies. And so you have to try to figure out what this stuff means. Justice Breyer says you have to try to think broadly of what Congress as a collective institution, or for that matter, the administrative agencies are trying to do, and judges should view themselves as allies of those people who wrote the laws. Or you read them as bare texts without paying attention to the purposes. I am more with Justice Breyer, but textualism is not a stupid argument at all. But the point I want to make is that the heart and soul of this debate has almost nothing to do with the Constitution, because one of the things I often point out is that we don't litigate when inauguration takes place, because all of us, wherever we are on the political spectrum, will agree that January 20th means January 20th. We don't litigate the fairness or unfairness of Texas being limited to the same two senators as Vermont. What part of two do you not understand? What we litigate will be the 14th Amendment, but much, much more importantly, the complex statutes, the whatever it is, the 1,000 pages of the Affordable Care Act. I don't know how much time Judge Eskridge spends on ERISA cases, but to put it mildly, they're not fun, I would predict. And constitutional lawyers have nothing of interest to say about what one should do when trying to figure out what ERISA means in a modern society where almost nobody any longer has defined benefit pensions. Indeed, they've been replaced by other systems and so on and so forth. I'd be willing to go on all evening. I suspect all of you have better things to do. So, I will say my goodbye when Judge Eskridge tells us to, but I really do wish we had much more time.
It's an incredibly, it's a great discussion. And I would continue, but I was going to invite Matt to come back on to tell us if we are in fact at a conclusion here.
I think we are. I think we're at a conclusion. And big thank you to all of y'all, to Professor Levinson, Professor Werman, Judge Eskridge. Thank you so much. And to the students, we hope to see you next week. Next event is Tuesday, same time, same place, for discussion about regulatory reform. Thank you.
Thanks, everybody.
Thank you all.
Thanks, Professor Levinson and Judge Eskridge, and thanks to all of you for showing up on Zoom. I'm impressed, actually, that there was so many. So thanks, everybody.